Hello all and welcome to our webinar, The New Rules of Procedure of the Epo Boards of Appeal. I am Niklas from Management Circle and your host for today's webinar. If you have any question during the webinar, feel free to contact me via chat. But first, let's have a look at our schedule. Our speakers will speak about 50 minutes, so we are going to have enough time for your questions. If you have questions, please feel free to write it into the chat so that I can ask it to our speakers. Also, we plan a Q&A session at the end of the lecture. You find the chat in the menu of the GoToWebinar platform on the right side of your screen. If the panel has folded, you can reopen it by clicking on the orange arrow you also find on the right side of your screen. Also, we have prepared surveys, which we will display during the webinar. We would appreciate if you participate at the survey to get to know your opinion. So this webinar is part of the IT Service World, which will take place this year on the 23rd and 24th November 2020 in Munich. With participating at this webinar, you have the opportunity to register for this webinar with a discount of 50% thanks to Croissant Slovak. Just visit our website ipserviceworld.com and use during registration the code CNF20. I am looking forward to meet you on site. Okay, and now I'm happy to introduce you to Ms. Dr. Natalie Kirchhofer and Mr. Dr. Arvid Burrichter, our speakers for today's webinar. I wish you all a great and very informative time. Ms. Dr. Kirchhofer, you can start.
Yes, welcome everybody also from our side. It's a great pleasure to see so many virtually of you today. So my name is Natalie Kirchhofer. I'm here with my partner here at the firm, Arvid Burrichter. We're both partners at the firm. I'm a patent attorney and biochemist by training and in the life science division here at COAS in Florac. And Arvid, want to say something to yourself too?
I'm an organic chemist by training, and both Natalie and I do a lot of EPO opposition and appeal work, especially in the field of chemistry and the life sciences. And it's a great pleasure now for Natalie and me to take you to spend some time and take you through the exciting topic of the new rules of procedure at the boards of appeal.
Yeah, and as we have a lot of external viewers today, let me just briefly tell you something about COAS and Florac for those who do not know us yet. We're a patent law firm, a patent and trademark law firm based here in Düsseldorf, Germany. We have patent attorneys and attorneys at law. We represent here more the patent team, but we are also very strong in trademarks. And as Arvid already said, we have a strong focus on contentious proceeding, patent litigation, but also invalidity proceedings, especially at the EPO. We are both from the chemistry and life science space, but we also have a very strong focus on electronics and mechanical engineering here in the field. We have a rich history, being founded in 1954, and are among one of the top 5 patent attorney firms in Germany. Yeah, so let's then just start directly into the topic. We have introduced ourselves now a bit, and just so that we can, adjust our presentation also to your needs, it would be interesting to learn a little bit about you. So we would like to pose the first survey question to you, just to know how much experience you actually have with the new rules of procedure at the EPO. And so the question is, how familiar are you with the EPO appeal proceedings at all? And so please select the answers, whether not at all, or you have only observed a few cases, or you're regular at the boards of appeal with 1 to 5 cases or greater, 5 cases per year. And Niklas will let us know the results.
Okay, there are 45% who say I've observed a few cases.
Okay.
Then 30% says there are 1 to 5 cases per year. 15% have over 5 cases per year, and 10% haven't appealed at all.
Okay, so it's quite a mixed crowd, but I think it's yeah, we will go through the new rules step by step. So it's definitely also okay for those that are not so experienced. But at least we always think also for the more experienced attorneys, it's good to also have a look at the original text and actually see what has changed. Yeah, and we of course look forward to your questions also during our talk, especially from the more experienced colleagues, of course. Yeah, so. Then let's dive right into the topic with an overview, Arvid.
Well, let's take a quick look at what this reform of the new rules of procedure is all about, what it wants to change, and how it actually changed things. As you all know, the new rules are in force since January 1st of this year. We now have roughly about half a year of experience with the new rules. And if you look at the explanatory notes of the reform, these indicate that there are really three main objectives of these new rules. The first is to improve the efficiency of the proceedings. The second is to improve the consistency of the proceedings, and thirdly, to predict the predictability of the proceedings. Now, why improve efficiency? Well, as you may know, there's a huge backlog at the EPO Board of Appeals. The average time average duration of appeal proceedings is about 5 years, or was about 5 years. The EPO has the ambitious goal to cut this down to about half. So to cut it down to about 2.5 years. This is very ambitious, and the new rules of procedure are supposed to help here. Now, why improve consistency? Over the years, the different boards of appeal have developed different practices, especially with respect to the admittance of late filings. And it is a clear goal of these new rules to harmonize these practices and to have one practice that more or less all boards will follow. Now, how do the new rules want to achieve these goals? There are essentially two central elements here. The first element is a new case management system that controls the appeal proceedings, and the second element is to introduce clear rules on late filings. So to introduce articles that specify what is admitted at what stage of the appeal proceedings. As we will see in just a minute, there are 3 levels of convergence that are introduced here that regulate what can be filed at what stage. Now, what impacts do the new rules have on the various participants of the system? Well, it has quite significant impacts. First of all, it has an impact, of course, on the boards of appeal themselves. They have to follow a new case management system. It also has a quite significant impact to the parties to appeal proceedings, especially with regards to when to present your arguments and also your auxiliary requests. It has an impact on not only to the appeal proceedings themselves, but also to the first instance departments and parties, because it is expected that there will be a significant front loading of the cases. So much more will have to be presented than it was under the old system in the first instance already. And finally, it also has impacts on the enlarged Board of Appeal, which is the board that will harmonize and also expected to harmonize the various practices of the implementation of the new rules of procedure in the various boards.
Yes, and as Arvid already mentioned, there are two blocks, so to say, of changes. The first concerns the case management, and this will also divide our talk a bit. We will first talk now about the new case management measures, and then the second block concerns Articles 12 and 13 of the Rules of Procedure, which are at the substance of the appeal proceedings, what forms part of these appeal proceedings, and then the provisions on late filing and amendments. This slide here just gives you an overview. It's more a slide that you might turn back to later if you review this presentation again, because it shows you where the changes to the case management have been implemented, and you see on the bottom a timeline from filing the notice of appeal, grounds of appeal, and the response then to the summons, to oral proceedings, the preliminary opinion, the communication by the board, and the oral proceedings. And you can just see that that the case management measures really affect the entire proceedings, and we will walk you through these new case management measures one by one.
Yeah, before we do that, let's take a quick overview at the main features of this new case management system. Article 1.2 introduces some changes in the board's internal case management system. In particular, it requires the boards to inform the parties when oral proceedings can be expected, and we'll turn to this in a minute. Then Article 10 Rppa contains some changes with respect to how two or more proceedings can be consolidated and how appeal proceedings can be accelerated. There are some changes to the current practice, to the previous practice. Then Article 15.1 Rppa introduces some changes with regard to the summons to oral proceedings and also the preparation of oral proceedings. Article 11 Rppa regulates the remittance, the grounds for the situations when cases can be remitted to the first instance. And finally, Article 15 Rppa gives the boards the possibility to, in certain cases, under certain circumstances, write an abridged decision. Yeah, let's maybe turn now first to the first element here, Article 1.2 Rppa. Now, Article 1.2 Rppa requires that before the beginning of a working year, each board draws up a list of the cases in which it is likely to either hold oral proceedings, to issue a communication under Rule 102 EPC, or to issue a decision in written proceedings in that year. Let's take a closer look at the wording of Article 1.2, new Article 1.2. It reads, the chair.
And by the way, if I may interrupt you, the design of our slides is maybe not the most beautiful one, but we tried to create a track changes mode here, yeah, so that you really see at first sight what is new, right? So as you may be familiar with from the word track changes mode, the red means addition, and the particularly a lot of red stuff is just, you know, wording, but the red stuff that's really important we highlighted in yellow. Yeah.
So everything that's important is in yellow in the original text here. So Article 1.2 reads, the chair of each board shall, before the beginning of each working year, draw up a list of the cases in which the board is likely to hold oral proceedings, issue a communication under Rule 100, or issue a decision in written proceedings in that year. The president of the boards of appeal shall, before the beginning of each working year, publish the list of each board. Now, you may have seen this list already. It was first published in the fall of last year. I think it was in November or late October last year. This is a very important new element because, as we will see in a bit, the summons to oral proceedings triggers the third level of convergence for the admissibility of late file submissions. So once the summons issues, it is much harder to get any new submission admitted, and that's where this list comes in. It's supposed to help you to tell you when you can expect oral proceedings. However, be careful here. The list will tell you when when you can expect the oral proceedings, but it will not tell you when to expect the summons to oral proceedings. And the summons is all that matters for that, for that third level of convergence. So the summons, of course, will be issued much earlier. It will be issued at least 4 months in advance of oral proceedings. So if you see that your case is on that list in November or in October, it's really time to hurry and to review your case and make sure that you have nothing to add to your case before the summons to oral proceedings issues. Also, there are changes to Article 5 RPBA, and these changes are quite significant because under the new rules, the composition of the board was fixed right after filing the appeal. So when the appeal started, the chair had to fix to assign both the rapporteur and also the legal member to a case, and this is was supposed to stay for the whole duration of the proceedings, which could take 4 to 5 years. Now, this had led in the past to a significant delay of the proceedings because especially the availability of legal members was limited, and the new rules now changes this, and they say, if you look at in Article 5.1, that only the chair and the rapporteur are appointed right at the beginning of the appeal proceedings, and the third member, which is typically the legal member, can be appointed at a later time. This gives the board and the case management more flexibility, and this will hopefully resolve the problem of delay and help speed up the proceedings.
Yes, and you already saw here in Article 5.3 that also a further responsibility that the rapporteur now has, subject to the direction of the chair, is also to assess already on his or her own a bit of the subject matter of the appeal and decide whether that appeal should be given priority. And this leads me to the second case management topic we want to discuss, is that the new RPBAs offer the boards the possibility to organize their case schedule a bit more flexible and a bit more subject matter wise. So they can consolidate interrelated appeals, so appeals where they think they belong together, should be heard together because they have very similar subject matter. So it could be divisional applications and parent applications, or priority applications and parent applications. And also the measures for acceleration, which have already been in place, are now codified in the new Article 10. And it's especially this Article 10, paragraph 2, where you see that if appeals are filed from separate decisions but are clearly connected to each other, then they should be examined by one board of the same composition, and the board shall endeavor to deal with them one immediately after the other, and the board may, after having heard the parties, also deal with them in consolidated proceedings. So after having heard, so there's the requirement to hear the parties, but as you see, the consent of the parties is not absolutely required. Yeah, it will be interesting to see what the effects are and also what you as users of the system think of this provision. It seems to be quite divided. There are, of course, patentees who have made use of also scattering their cases among different boards and also in different time scales to just prolong legal uncertainty regarding the patent family. We've heard of a lot of parties who are often on the opponent side that they actually welcome this measure and they hope they will get more consistent decisions here across patent families or related cases. The paragraphs 3 to 5 here, it's a lot of red text, but actually all of this text more or less was already in the official journal notice on acceleration of proceedings. What's now new here in yellow is that the parties shall be notified of the decision, whereas substantively this measure was already in place before. At least it's our preliminary view that the boards actually make more use now, are a bit more flexible in granting these acceleration requests, right? Whereas formerly it was more or less only if an infringement proceeding was really pending or imminent and you had to prove that acceleration was granted. Now we have seen several cases where acceleration was granted with no infringement proceedings pending. It seems to be that they are more open and flexible to these acceleration measures. So make use of it if it applies to your case.
Then the next element in the new case management system is Article 15.1 RPBA. This now provides some clear rules with respect to the scheduling of oral proceedings. There should be at least 4 month notice of the summons to oral proceedings and inter partes proceedings such as opposition proceedings. The summons shall be issued no earlier than 2 months after receipt of the written reply to the grounds of appeal. Now, this is important because it will give you at least 2 months time to under the second convergence level to file a reaction to the counterparty's submissions. So you can be sure that after you receive the response to the grounds of appeal, that you have 2 months time before you receive any summons.
Of course, not so much, right? Depending on your workload, 2 months is quite little actually.
Yeah.
Often, yeah.
In practice, of course, this will be a longer time. At least in the near future, it will be a much longer time. However, it's important that everyone is aware of the risk that once in summons issues, there is very little you can do to file and to get new submissions admitted. Finally, the boards are now required to issue a communication drawing attention to matters that seem to be of particular significance for the decision to be taken. This is so like in the first instance, the boards are now required to do this. They are not required to give a preliminary opinion, but they at least must point out which points shall be discussed at oral proceedings. Now, in the past, there were some boards that regularly issued these preliminary opinions. There are other boards that never issued these preliminary opinions. This now harmonizes this practice. In our opinion, this is a very good change because it allows you to focus on the important issues at oral proceedings.
Yeah, the next point regards remittal, right? The Article 11, which of course was already present in the old rules of procedure, but whereas previously you see it here strike through the Article 11 read a board shall remit a case to the Department of First Instance. It's now turned around, as many of the provisions are. The default situation changes, and now the new Article 11 says the board shall not remit a case to the department whose decision was appealed unless there are special reasons, right? So the default is no remittal. Only if special reasons are there, remittal is granted. And of course, fundamental deficiencies, violation of right to be heard or so forth is still, of course, a reason to remit. It was our expectation, or we still think that in the long run, remittals are less likely, so you should work under the presumption that no remittal will take place. However, we have done a review of the case law now in the first half of this year to see how Article 11 is actually applied. And in fact, we see that there are a lot of cases remitting to the first instance. So we've just pulled out several examples for you here in green, and you can check out these T decisions if you're more interested in this, but it still seems to be the case, at least now in the beginning, that boards still are remitting. It might be because they want to also clear their backlog in this way by making the proceedings now faster. So if first instance only decided on added matter, for example, they will only deal with this issue and remit back there. Our expectation was that they might now decide through, but there is a tension between Article 11, which says the board shall not remit unless special circumstances present themselves, and Article 12.2, which we will see in a minute, which says that the appeal proceedings should be based on the first instance decision, and of course what the parties presented during appeal. So if the decision was only about Article 123, and in the extreme case, if the parties on appeal only present submissions on this matter, it's of course hard to imagine that a board will still decide the case through if it reverses the first instance decision on added matter. But that's definitely something to keep in line. We would say right now there's relatively much uncertainty regarding the chances of remittal. So that's why you should definitely keep in mind that there may not be a remittal too in the future.
Yeah, and that takes us now to the final point in the new case management system. That is Article 15 Rppa, which gives the boards the possibility to write abridged decisions under certain conditions. Essentially, there are two conditions under which they can do this. The first is when all parties explicitly agree. And the second possibility is when it's not necessary to set out in full the reasons for the decision, because the decision is based on the findings and reasoning of the contested decision. So essentially, if there is if there are no new arguments on appeal and parties more or less only repeat what was already presented in the first instance, this article now gives the board the possibility to write an abridged decision, essentially to only refer to these to the reasons given in that first instance decision. Now, we looked through the case law and we digged out two decisions that are actually abridged decisions. The first one is T1687 of 17, and the second is T2227 of 15. In both cases, there was a situation where parties relied on first instance arguments and did not present anything in addition. And in these cases, the board simply referred to the reasoning of the first instance decision. We are not completely certain, and it will be interesting to hear your views about this, about situations where both parties would agree on an abridged decision, because typically one party might be interested in a full decision, the other party to an opposition will be interested in an abridged decision, but we could not see a situation where both parties would be interested. As I said, we are keen on hearing your view on this. Now, this was the last major element of the new case management system, what we would like to do is here at this stage do a little further survey here to see how you like these formal changes in the case management system. So if I can turn this to you, Niklas, to conduct the survey. What we would like to hear, what is your opinion on the case management measures implemented by the new rules of procedure? The answer one is, I like them because they allow the boards to manage the cases in a more flexible way and will hopefully lead to more efficient and faster proceedings. And answer number two is, I don't really see a need for them. The old system worked well and there was no reason for a reform. So if you could participate.
Yeah, and Niklas, please let us know again once you see the results. We expect a clear favoring of the first option.
Yes, you're right. It's very clear. There are 87% who voted for, they seem to be a very good idea, and only 13% who don't see a real need for them. Did you expect this?
13%, yeah, that's still interesting, yeah. Very well. And Niklas, if there are questions during the presentation, just please interrupt us orally. We have here the slides on full screen, so we don't necessarily see your video. So please just interrupt us if you have any questions. Enter them into the chat, and Niklas will pose them to us. So this was the first part of this webinar on the case management. Let's now turn to the substance of the new rules of procedure, and this is really at the heart of the rules of procedure are these articles 12 and 13 in particular, which provide what actually forms the basis for the appeal proceedings and what you can still argue and file at the beginning and during the appeal proceedings. And as Arvid already mentioned, the boards have introduced already in the past decade by way of their case law, but this has now been codified, so-called 3 levels of convergence, which we have also tried to depict here for you in this illustration. And in principle, what they would like the proceedings to be like is that you have a certain block of subject matter and objections and issues that were raised in the first instance, and this led then to the first instance decision. And in the ideal world, the appellant should then review that and decide what aspects of the decisions he actually disagrees with, and then the grounds of appeal should, in the ideal world, be limited, so more limited in subject matter than the first instance decision. So you see this convergent way that the subject matter is narrowing down. And then the new rules of procedure essentially provide that what you have fixed to be your case on appeal, so the first level of conversion, that kind of sets the limits what you are confined to argue during the further process of the proceedings. And again, the ideal situation in the eyes of the boards of appeal is that the closer you get to the oral proceedings, the more the parties narrow down on the subject matter that is most essential to the case or most contentious. What one of course sees in practice is often that actually new issues arises, and this is then not conversion, but you actually open up new issues, and this is exactly what the new rules of procedure want to avoid. So they want to force you in this corset of convergency, and we will get to these points one by one, what is actually still allowable if actually you need to deviate from the first instance subject matter. And we have Article 12. We will go through the text in a minute in more detail, but it's important for us to point out that in the former version of the rules of procedure, Article 12.2 read that everything presented in the grounds of appeal, so the entire submission, will definitely be in and be the subject matter of the appeal proceedings. Already this has changed. So it's no longer the case that everything you put into your grounds of appeal will form the subject matter of the appeal. Already at this very first level, there are restrictions, and we will see them. And another important change is next to prescribing what is allowed and what is not allowed. The new Articles 12 and 13 also at all of these three stages require parties to identify amendments. So it's not up to the board to kind of compare your first instance submissions to your second instance submission and then find out themselves what is new. You yourself have to identify amendments and also provide then already the reasons for presenting the amendments. And we will see what this looks like in the wording of the provisions. So we will divide the talk again. I will now spend a couple of slides on the very first level of conversion, so regarding the grounds of appeal. Article 12, here is the relevant provision. You see it here in Article 12, paragraph 1. Not too much has changed. A new littera A has been introduced, that the appeal proceedings shall be based on also the decision under appeal and minutes of any oral proceedings. That's seen by many as a mere clarification. It will be interesting whether this actually really means that, for example, everything in the decision under appeal is automatically the basis for the appeal proceedings. So you could imagine situations where the decision actually touches on many different aspects and perhaps even grounds of oppositions, and then the grounds of appeal actually only address a very limited set of these issues. And it's at least our opinion that what we will see in paragraph 2 that overrules paragraph 1 littera A. So in case you yourself as an appellant focus only on one part, then Article 12 paragraph 1 littera A does not mean that regardless everything that's mentioned in the decision is in, but this will remain to be seen. At least you could try to argue later that Article 12 paragraph 1 littera A allows you also later on to refer to aspects mentioned in the decision, but this will be seen. Littera E here is interesting. It refers to minutes of any video or telephone conferences, and this was already pre-corona. So you see here that the boards indirectly, by referring to these, have opened the door to conduct at least something like case management conferences by video or telephone conference. Of course, we've seen this now with the corona pandemic. Before that, we hadn't yet seen this. It will be interesting to see whether this will stay on. In principle, we think it's a very good idea, not the whole oral proceedings, but perhaps a pre-conference on formal matters to just pull out substance from the actual oral proceedings would be a good idea. At the heart of the appeal law here in the RPBA is Article 12.2, which now really brings it to the point. So in view of the primary object of the appeal proceedings to review the decision under appeal in a judicial manner, so that's the primary object, so no new facts or arguments. The primary object is to review the decision. A party's appeal case shall be directed to the facts, requests facts, objections, arguments, and evidence on which the decision under appeal was based. So this is the default, right? That's what's shown here, that you should not exceed kind of the subject matter block that you had in the first instance. It must be the same or less. This is the new normal, so to say. Then Article 12.3 is similar to as it was before. So your grounds of appeal shall contain a party's complete appeal case. So you should really put in everything that forms your appeal case. Also, if you draw it in from the first instance submission, you should still present it as part of your grounds of appeal. And then the consequences of not doing this come here in Article 12, paragraph 4, where you see any part of a party's appeal case which does not meet the requirement in paragraph 2. So that's something that the decision was not based on. If you bring something new, it is regarded as an amendment. And now comes something very interesting. The second part of the sentence, unless the party demonstrates that this part was admissibly raised and maintained in the proceedings leading to the decision under appeal, So here you see that what they consider an amendment can even be something that you already presented in the first instance, but which the decision was not based on. So that's something to think about. I mean, here from the second part where they say that this part was admissibly raised and maintained, it again underscores the importance of maintaining your first instance submissions, right? So you should never, in the first instance, expressly say that you no longer maintain something, but it's a bit questionable why they put this in here so expressly. So in our opinion, it is recommended at oral proceedings in the first instance to really make sure that also the minutes reflect that you are actually incorporating or pointing to your entire written submission, so that it's not construed as if only what you have presented at the first instance oral proceeding is actually what you relied on and what the decision is based on. But this will be interesting to see how this is dealt with. But I, for example, spoke with Ingo Beckendorfer, who's one of the drafting members of this for these new rules of procedure, and he does see this as a backdoor for the boards to actually say, for example, if in the first instance you filed 60 auxiliary requests, then he is at least of the opinion that this provision says that it's not automatic that these 60 requests will enter the second instance. So they need to be admissibly raised and maintained. But important here, the second paragraph, what I already mentioned, the party shall clearly identify each amendment and provide reasons for submitting it in the appeal proceedings. And then the discretion of the board, the last sentence, it shall exercise its discretion in view of, inter alia, the complexity, the suitability of the amendment to address the issues which led to the decision under appeal and the need for procedural economy. But you see already here that in the grounds of appeal, under the new provisions, you will need to spend more time, or you at least will need to spend at all some words on what part of your submission is actually new, and why do you bring it only now, and why did you not bring it in the first instance, or why did you not maintain it. So also in this regard, the recommendation is, of course, in the ideal situation, try to present your complete case already in first instance, so that on appeal you do not have to spend so much time discussing and arguing whether the new arguments should be entered. Then the explanatory notes we noted here, interpretation of the law, so purely legal arguments seem to be excluded. That's not an amendment. Yes, and also you will see there are transitional provisions, which we will come to at the end, which are very important, and all of what you see here now in Article 12, so dealing with the grounds of appeal and the reply. Here, grounds of appeal and replies that were filed before entry into force, before January 1st, 2020, they are exempted from these new provisions, and here the old provisions still apply. But every ground of appeal that was filed this year already falls under the new provision. Yes, then we have Article 12, paragraph 6, which says that requests, facts, objections, or evidence which were not admitted in the proceedings leading to the decision under appeal shall in general not be admitted unless the decision not to admit them suffered from an error in the use of discretion and so forth. This is interesting because the first instance, as you may have experienced yourself, has also been very keen on expediting their proceedings, and the way in which the first instance does this is that they also are relatively strict now on admitting new facts and evidence. And you see here that if you have the situation where your arguments or documents or requests were not admitted in the first instance, you really have a hard time getting them admitted into the appeal proceedings. So also there, the recommendation is in the first instance and within the first instance, as early as possible, file your complete case. So we have actually changed our recommendation practice already quite a while ago, that we now recommend already for a patentee, for example, with the response to the opposition, to really carefully create an auxiliary request strategy and actually file them already at this early stage, because it just circumvents all of these discussions whether or not they were filed timely. Yes, I think that's all we need to say to this first level of conversions, and let's look at the second level now.
Yeah, and the second level of conversions applies to submissions that are filed after the deadline for filing the grounds of appeal or the response to the grounds of appeal, and before receipt of the summons to oral proceedings. Now, this level is governed by Article 13.1 RPBA. The standard for admissibility is stricter than at the first level. The new rules require that any amendment to an appeal case must be thoroughly substantiated. That means you have to explain what is new and why it was not filed earlier. Typically, you will have to point out that your answer is a response to a new argument, for example, to any new facts and submissions from the counterparty. The admission of your new of your amendment is subject to the board's discretion, and importantly, where an amendment to a patent application or a patent is concerned, the applicant or the patentee must explain first why the amendment prima facie overcomes the objections raised, and secondly, that the amendment prima facie does not give rise to any new objections. And here, with regard to the last point, you have to be extremely careful under the new rules that the auxiliary requests that you file under the second conversion level are clearly allowable and don't lead to any new objections, because if they do lead to any new objections, for example, to clarity objections or to Article 123 objections, then this will be a reason for not admitting your auxiliary request, your new auxiliary requests. Now let's take a look at the wording of Article 13.1. It reads, here you can see, again, this is the redacted version where the old text is crossed out and the new wording, you know, is not crossed out. Any amendment to a party's appeal case after it has filed its ground of appeal or reply is subject to the party's justification for its amendment and may be admitted only at the discretion of the board. The party shall provide reasons for submitting the amendment at this stage of the oral proceedings. And now, in the following paragraph, there are guidelines for the board how to exercise its discretion. And if you see here that the text reads, the board shall exercise its discretion in view of, inter alia, the current state of the proceedings, the suitability of the amendment to resolve the issues which were admissibly raised by another party in the appeal proceedings, whether the amendment is detrimental to procedural economy, and in the case of an amendment to a patent application or patent, whether the party has demonstrated that any such amendment prima facie overcomes the issues raised by another party in the appeal proceedings or by the board and does not give rise to new objections. So the requirements for admissibility at this level are much higher already than at the first level, and we see another difference when going to the third level of convergence. Now, this level of convergence starts with receipt of the summons to oral proceedings. Now, as we said earlier, this is not necessarily the date of the preliminary opinion. In practice, our experience is that the preliminary opinion comes after the summons. The boards actually issue the summons quite early, and then the preliminary opinion comes maybe 3-4 months before the oral proceedings, but after the summons. Now, as we said, you really don't know when the summons will come. You have to be prepared for that summons as early as 2 months after the deadline, after receipt of the response to the appeal. Now, the admissibility at this stage is governed by Article 13.2 Rppa. These are the strictest standards here. The basic principle is that at this level of convergence, no amendments to a party's case shall be taken into account. Only if there are exceptional circumstances, an amendment can be allowed. Now, this is very strict. This is, if you compare this to the language that was in the previous rules, the previous rules said that read that amendments sought to be made after oral proceedings have been arranged shall not be admitted if they raise issues which the board or the other parties cannot reasonably be expected to deal with without adjournment of the oral proceedings. So adjournment of oral proceedings was the standard under the previous rules. So you had to explain why your amendment would not necessitate an adjournment of oral proceedings. Now, under the current, under the new rules, the basic principle is that nothing at this stage is admitted, and only in exceptional circumstances something can be admitted. That's quite a significant change, and that's why there should be so much caution that you don't miss or that you're not surprised by a summons in a case. Now, it's important that this new Article 13.2 does not apply to any cases in which the summons was issued before January 1st of this year. So the transitional provisions say, as we will get to this in a minute, they say that this Article 13.2, this very harsh rule, does not apply to old cases where a summons was issued last year. However, one needs to be aware of that Article 13.1, so the second level of conversion, always applies, also to old cases. There, I think in view of timing, we could skip this.
Yeah, I mean, this Article 51 is just the provision on timing, that when the decision is to be expected 4 months after the hearing. Let's just quickly look at the transitional provisions to conclude the presentation. It's in Article 25 Rppa, also the final article in the rules. And in general, paragraph 1 of Article 25 says that the Rppas, the new rules, apply to all pending appeal proceedings, so regardless of whether the appeals were filed before or after entry into force. And then there are 2 exceptions only. And the first one on the left here, Article 25.2 Rppa, says that if your grounds of appeal were filed before entry into force, so it's the grounds of appeal that count here, or any reply filed to it. So the reply can also be in this year, but if the grounds of appeal were filed last year, then Articles 12, paragraphs 4 to 6, which relate to the grounds of appeal, there the old versions apply. And the second exception here on the right is Article 25.3, which stipulates that this third level of convergence, which you saw in Article 13, paragraph 2, that this only applies or does not apply to cases where you received the summons in last year, right? It will be interesting to see how now, due to Corona, we had a lot of rescheduling where you actually received old summons last year. So you thought Article 13.2 did not apply to your case, but now it was rescheduled and you received a new summons. So there the question is what actually applies. That will be interesting to be seen. But what's really important here, what we want to point out, is that what is not exempted is Article 13.1. The second level of convergence, so any submissions filed after the grounds of appeal. So that might be submissions that you filed 2 years ago. Retroactively now Article 13.1 applies, so actually you should have marked all amendments in that brief, should have explained why you filed the amendments and so forth, which probably you didn't do because you were not yet aware of the new rules of proceeding. And we see now in the decisions, we've reviewed them that have come out now under the new rules in January this year. They all already applied this. So saying that Article 13.1 applies retroactively, that's pretty clear from the case law. Yes, and with this, I think we can sum up the implications that the new rules of procedure have for you, and also our first experiences with them. You want to start, Arvid, maybe?
Sure. Now, I think one thing you can say is that there is an extreme front loading under these new rules of procedure. Starts with the first instance, but also in the second instance. So the clear advice is bring all requests, facts, objections, arguments, so everything as early as possible, possibly already in the first instance. As Natalie said, we have started already a while ago, and we think that is the right decision to present auxiliary requests and think about an auxiliary request strategy already very early on, pretty much when receiving the notice of opposition, just to avoid any discussions on appeal, whether they were filed in a timely manner or not. Now, for auxiliary requests, it's very important on appeal to fully substantiate them. So to bring all arguments and objections, to explain what problems, what objections the auxiliary requests resolve, to identify any amendments, in brief, and provide reasons for submitting them, so auxiliary requests at this stage. Now, this will inevitably lead, and that's our experience already, to longer submissions and also to a stronger focus on procedural issues.
Yes, and as we said regarding Article 11, you should always work under the presumption that your case will not be remitted to the first instance. So in your grounds of appeal, you should also address issues that the first instance decision did not decide on. Then you should also work under the presumption that actually the proceedings will speed up now. So together with these changes in the rules of procedure, there were also now a lot of new employments. So the boards of appeal have grown in members, and it can be expected that this will reduce the backlog. And you should be aware that these convergence level could apply to you quickly, because you might receive now a summons for which under the old system you would have thought you still have 1 or 2 years time. So be aware of that and review your pending cases. And for this, the list of cases is of course very instructive, although as Arvid said, it doesn't prevent you from being maybe surprised by a summons even for a case that is not on the list, because the list only relates to oral proceedings and decisions taken in the following year. And as I already alluded to, there was also structural reform in the boards of appeal. We've seen 33% new hires in 2019 of technical members. So the boards of appeal have grown, which is good from an efficiency standpoint. What has not grown, interestingly, is the number of boards. So we now have the situation that a chairman is responsible for a larger group of members, which also means that the chairman, if he really serves as chair in all of his proceedings, will hear more cases, and on the converse side will probably be less prepared in the oral proceedings. Same for legal members, they were actually not retained to the same degree. So in our opinion, you should place even more emphasis in the oral proceedings to really explain your case again in simple terms so that actually all members can also follow, because you cannot expect all 3 of them to really have reviewed your file closely, even if they won't admit to this. And this brings us to the end of our presentation. We would like to conclude again by hearing from you how your views are on the new rules of procedure, now the substantive part. And you might be in favor of them. The arguments pro are usually that they provide a clear guidance, enhance the predictability, ensure efficient and faster proceedings, and also avoid last-minute surprises. But you also might be against it, and here the reasons are usually that there's way too much focus on form rather than on subject, that in the end wrong decisions are taken because documents, requests, and so forth are not admitted. And regarding the requests, a lot of contra opinions say that the patentee is put at an exceptional disadvantage. Yes, and we're curious to see how your views are on this, Niklas.
Yes, so here's the result. There are 68% who see it critical. There are 21% who are in favor of it, and 11% haven't made up their mind yet. So this is, yes, a very clear thing. It changed in the meanwhile. Did you expect this?
Yeah, I mean, we only provided for one answer being allowed. I think there are good arguments for both, and probably many of you might also have clicked on both of the first 2 options, because there are of course good and bad sides of it, and also it always depends on which side you are on in the particular case. Yeah, but in general, I think as we represent a lot of patentees also, we especially also view this point with putting the patentee at a disadvantage. Critically, if then a patent is revoked because, for example, an amendment is no longer allowed.
Contrary to the opponent, the patentee only has one chance, right? If he loses the opposition proceedings on appeal and the patent is revoked, there is no second chance, whereas the opponent can always go for a nullity suit, even if he is unsuccessful on appeal. So this makes it particularly tough for the patentee, and that's why, in our opinion, the patentee has to really pay particular attention to these new rules of procedure.
Yeah. Are there any questions from the audience? Please enter them into the chat if you have any questions, or maybe also comments, first experiences, remarks. Otherwise, you can of course also contact us later. I'm aware that the time is already a bit progressed.
Yes, you find the chat when clicking on the orange arrow in the right top corner of your screen. So if it's missed. So there's one question already. They are asking, have you already had oral proceedings under the new Rppa? What has changed?
Wanna take that on? Yes, we had, I mean, due to the corona pandemic, we had a lot of cases scheduled, but they were rescheduled now. But actually before March, we already had a couple of cases, and it's of course not representative. It really depends on the board that you are facing. It depends on whether that board was actually in favor of the rule change, and also our experiences also depend a bit on the age and flexibility of the chairman. So there are definitely also some that feel that not much has actually changed and they do business as usual. But I would say especially the younger chairman, and if you have a chairman like Müller or Beckendorfer who are really involved in drafting the new rules of procedure, they expect you to be alerted and also to know the new rules of procedure.
Okay, great. Then there's another question. Do you have practice tips regarding the drafting of the grounds of appeal under the new Rppa?
Yes. Well, I think one very simple recommendation is that by way of routine, you should try to incorporate everything you have written in the first instance in your grounds of appeal. And our experience is that it's best to do that by actually, copy paste, take the arguments from your previous submissions from the first instance and reintroduce them or introduce them into the appeal proceedings, rather than referring to any statements from the first instance or attaching the first instance briefs to the grounds of appeal, because it simply makes it simpler for the board to read. They want to get an overview and want one document where they can later on refer to, and that's probably the key recommendation. Make sure you present everything again from the first instance.
Yeah, and what we now also sometimes do to find a middle ground with this, marking amendments and saying what is an amendment, to conversely put maybe a footnote into the submission to say where this argument can be found in the first instance, so that for the rapporteur it's always clear what is old and what is new.
Okay, thank you. And so far there's one last question. Is there a way to challenge a decision of the board not to admit late filed documents or requests, in particular during the oral proceedings?
Well, I mean, in general, the appeal proceedings are the final instance, so there's no general further review, except for a petition for review that can be filed, but on very limited grounds. And the ground that would apply here is the violation of the right to be heard. And at least we have heard from some board members, which were also involved in the drafting, that they actually think that the petition for reviews will increase, and that they also welcome this in a way, because they think it might lead actually to a consolidation or a review by the enlarged board of measures now taken. But what you should be aware, a requirement for this petition for review is that you need to raise the objection of your violation of the right to be heard as soon as it occurs. So if it occurs in writing, you should file a written statement saying, I raise here an objection, is Rule 106 EPC, that my right to be heard was violated. And in oral proceedings, you really need to speak up. You need to say, I raise an objection under Rule 106. Otherwise, your petition for review becomes inadmissible. Yes, are there any other questions? Otherwise, I think in the interest of time, I think we can also conclude the webinar now, but you see our contact information here, and we're really happy to follow up with you. So please contact us if you have any additional questions or remarks.
Yes. Also, you can meet Kyros and Florok at the IP Service World 2020 in November. You can register at the website ipserviceworld.com, and to get a 50% off, you can use the code CNF20. Okay, great. Thank you, Nathalie and Arvid, for your very interesting input. And yes, if you have further questions, contact our speakers with the contact details you see on the slides. And yes, well, that's it from my side. Thank you very much for listening, and have a great day.
Yeah.
Thank you very much from our side.
Bye-bye.
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 Our world. Our world is full of small and big miracles, full of fascination and inspiration. While some may see a dolphin, others see ergonomics and efficiency. For some, this is just an insect. For others, a revolution in the development of cameras and monitors. And some may only see simple leaves here, while others see the protection from dirt and water. Inventions are a part of our nature. But even if inspiration is omnipresent, in the end it requires a person to recognize it, adapt it, and develop it further. But what would our world be if no one were interested in inventions anymore? because research and development simply no longer pay off. An invention goes through many process steps until it is ready for series production. A problem has to be identified and a solution found. Research and testing are required. Product samples and prototypes have to be made. That costs time and money, sometimes even a lot of time and money. It would be all the more tragic if people then came along and took the idea away to use it for themselves, where all the energy, all the effort, and all the preliminary work then become more or less worthless in an instant. And what would it ultimately mean for society if inventions no longer paid off? Society would stand still, and things would not progress. That underlines how important it is to secure the development of ideas, because that is the only way to create something new. And that is exactly what German innovation protection ensures. Something that for us in Germany as a leading export nation is of particular importance. It provides security for the developers, for us, and for our future.